some points on cross-examination, I may need to get back up and do what's called redirect examination. I don't get to go through the witness's entire testimony again. I just get to ask a few more questions about any problem areas that I wasn't happy with or answers on cross-examination. When that's done, we then plaintiff call your next witness, and we go through this process, direct, cross, redirect, with every witness the plaintiff has. Once the plaintiff has put up all of her witnesses, the plaintiff rests. That means we are resting our case, Judge. That is our case. That's our people, our evidence, everything. Judge then says, defense, call your first witness. And we go through the same exact process again. Only this time, the defendant's lawyer is going to be calling his side's witnesses, so they're going to be friendly. He does direct exam. There are witnesses for the other side. I get up and do cross-exam. He gets to do redirect exam. When he has called all of his witnesses, then the defense rests. Sometimes, before the case goes to the jury, the plaintiff may decide that they want one more shot. And we would say, the judge would say to the plaintiff, plaintiff, do you have any rebuttal? That is, are there any other witnesses out there that the plaintiff has that you want to call because they can help, like, shore up the case, or this rebuttal witness can contradict something that came out during the defendant's side of the case that none of the plaintiff's witnesses during the plaintiff's part of the case testified to. So now I need to bring somebody in. It can be somebody who's already testified, or it can be a wholly new person. Okay? Or if documents came out that I want a chance to have witnesses on my side look at those documents and tell the jury why they shouldn't pay any attention to what's written there, because they hurt my side of the case, right? They came out on the defendant's side of the case. So I want to put a witness on who can try to explain away these documents that are not going to really help my client. Once that's done, the judge then, the case is basically done and submitted to the jury, well, except for closing arguments. So once that's all done, plaintiff gets up and does closing argument. The closing argument generally kind of mirrors, it's the other bookend to the opening statement. So you got the opening statement over here at the beginning where you're telling the jury all about the case. This is what the case is about. This is what we're going to prove to you. On the back end, the closing argument, sometimes referred to as a summation. You're summarizing the evidence for the jury. But you want to hearken back to your opening statement. You want to say, do you remember 6 days ago I stood before you and gave our opening statement and told you about the plaintiff's case. I told you were going to hear from witness Mary Smith and that she was going to testify to blank. And you heard from Mary Smith, and that's exactly what she testified to. Not only did she testify to that, but she identified certain documents that really assist my client, that prove my client's part of the case. Then the defendant gets up and does the same thing, closing argument. Defense lawyer puts his or her spin on the evidence, trying to tell the jury why the evidence the plaintiff has put up has not proven her case. And then the plaintiff's lawyer gets back up for a longer closing argument. Plaintiff goes for like maybe 10 minutes the first time, then the defendant, then the plaintiff again, and that's really only because plaintiff gets the last word because plaintiff has the burden of proof. Plaintiff has to come up with more proof than the defense does. So plaintiff goes first in the case and goes last in closing argument, just to kind of level the playing field in terms of what plaintiff actually has to prove. Once closing arguments are done, the judge then instructs the jury on the law. Sometimes referred to as charging the jury. So the judge gives the jury instructions on the law that applies to the facts of this case. Jury instructions or jury charges. Once the judge has completed telling the jury what the law is that they must apply, case, he dismisses the jury to the jury room where they deliberate, argue, discuss, talk to each other about the evidence, the witnesses, the documents. They can ask to cease the documents that have been introduced into evidence. If they have questions, they can write them out, and the questions are brought out to the judge. And the judge will answer the questions for the jury if he can. And that goes back and forth until hopefully the jury reports to the bailiff to go tell the judge they have reached a what? Verdict, right. So a jury decision is called a verdict. That verdict has to be converted by hocus pocus magic into a judgment of the court. The reason for that simply is the laws of civil procedure say that you can only appeal from a judgment. You can't appeal from a verdict. So the verdict simply has to be, if you will, blessed by the judge and adopted by the judge as the judgment of the court. There are some other things in there called directed verdicts and all that. You don't have to worry about that for purposes of the test. If the jury cannot reach a verdict, let's say it's a 12-person jury, they're split 6-6. What do we call that? A hung jury, correct. And this is important in a criminal context. In a criminal case, if the jury comes back hung, meaning they could not get the number of votes to either convict or say not guilty, that means they didn't reach a verdict. Therefore, the district attorney can retry that case to a different jury sometime in the future. But he can put that person on trial again with a different jury because this jury couldn't make a decision. I think as many times as he chooses, though with limited resources and things of that sort, that usually isn't more than twice. If you lose it twice, you got to start thinking, well, maybe there's something wrong with the case. The jury's just not buying it. However, in a criminal case, if the jury comes back and says not guilty, if they reach a verdict and they find the defendant not guilty, the district attorney can never, ever, ever put that person on trial again for the same crime. Why? Constitution of the United States protects criminal defendants from double jeopardy. So even if the DA says 6 months after the person's been found not guilty, the DA says, yeah, look, we found a whole bunch of new evidence. We got like new witnesses and everything. I'm going to retry this guy. We're going to see if we can convict him. No, you ain't. It doesn't matter if you discover new evidence. The party is over. The jury reached a verdict. That is the end of it. That stupid movie from umpteen years ago has nothing to do with reality, so ignore that. That wasn't the same crime. When I say they can't try him for the same crime, that means the same crime that occurred with the same victim on the same day, at the same place, during the same time frame. Okay, so if you then go off 2 years later and try to kill somebody else, that's not the same crime. Or even try to kill the same person you were put on trial for trying to kill the first time. If you tried and you didn't get it, and the jury comes back home, you can be tried for, if they come back home, you can be tried for that case again. But if they come back and say not guilty for killing this person on this day at this location, then, or trying to kill, then if they try to kill that person again in the future, that's not the same crime. It's the same victim potentially, but it's not the same date, it's not the same location, it's not the same place. It's got to be the exact same crime. That's what you can't be tried twice for. Jesus.
What happens if you're being tried and there's another lawsuit against you? Can that take place at the same time?
Well, first of all, are you talking about a criminal trial?
Like criminal trial, yeah.
So what do you mean? You mean there's other charges that aren't
Yes.
being...
Yeah, like,
Well, that's the DA's call as to whether they bring all the charges in one trial or
So they can find you guilty for killing someone, and perhaps there's another family accusing you of killing another member of the family.
Well, that's a different story, though. That's not, you're kind of talking about a civil case and a criminal case. Those are two different things.
Okay.
All I'm saying is, it's the DA's call as to what the person is gonna be charged with and what he's gonna be put on trial for. And any of the charges that he's brought to trial on, if he's found not guilty, those charges are over and done with. The defendant can walk out on the steps of the courthouse right after the jury says not guilty, call the press up and go, guess what? I did it. And those dumbasses couldn't prove it. Ha. You can do that, and they can't touch you. Cannot touch you. It's kind of stupid to do that. Well, OJ almost did it. His dumb book he wrote, right? What was that called? If I Did It. That was the book he wrote. If I did it, this is how I would have done it.
And did it explain how he did it?
Well,
I never read that.
he explained how he would have done it if he did it.
I know better.
However, that book ultimately was pulled, he wanted to write that story. You remember, well, you're not, most of you were probably not even born yet when that trial took place, but he didn't take the stand. That's his lawyer's call, right? Very smart move on the part of Johnny Cochran and that dream team, because OJ, he took a little too many hits to the head over the years. He wasn't gonna do himself any good. So his lawyer's like, no, dude, you sit, you shut up. You just be nice, right? He wanted to, all the stories, he was begging them. Because of course, with his ego, he thought, I can convince these people of anything. Look at his smile. You ain't gonna believe me. Let me talk to people. His lawyers are like, no, 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 no. And they don't let him. So, he's found not guilty, right? Years later, he decides to, well, a year or two later, he now has to undergo a civil trial because the families of the two people he was accused of murdering, the jury said you didn't murder them. We don't believe you murdered them, therefore you don't go to jail for it. But the families of the two people he is alleged to have murdered sued him civilly for money, for damages, for, there's a cause of action called wrongful death. You wrongfully caused the death of my loved one, and for that, I want your Heisman and every other penny you got hidden somewhere.
Was that before or after the book?
Before or after what? That was before the book. So he got nailed in the civil trial because the civil lawyers who were representing the families were way better lawyers than the fools who represented the state in the criminal case. They made so many mistakes, it's just not even believable. But the lawyer there, there's been a couple of documentaries on, and one of them shows actual footage from OJ's deposition in the civil case, where the lawyer for the Goldman family is asking him questions. And the guy is he's just a masterful lawyer. He asks the questions over and over in slightly different ways. And this is done over a period of several days. I don't know how many hours his depo eventually took, but it was a long one. And so the lawyer for the Goldman family would ask the questions in slightly different ways and did exactly what he was hoping to do, which was to catch OJ lying. Catch it. He'd say one thing, hammer on, no, this is the way it was, this is how it happened, this is how it happened, this is how it happened. You know, I never touched her, I never beat my wife, I never, ever put my hands on her. But what about the police call and you know about you went to the criminal trial, you were there, right? You heard them play those tapes where she called 911 and she said it was you, O.J. Simpson? Was she lying? Well, I mean, she just got upset that night. You know, we were both drinking and we had a little fight. I mean, it's no big deal. I didn't do anything to her. Okay, so first you did nothing to her. Now, well, I didn't really hurt her, but yeah, she did call the cops on me like 5 times. That sort of thing. So then he goes to prison, as you know, for the other stuff, the Las Vegas thing, where he's holding up people to get back from them said was his own sports memorabilia that these folks had ripped him off and were gonna make money off of. So he gets his posse and goes in with guns and goes, give me my stuff back. And they go like, yeah, not before we call the cops. The cops come, they arrest him. So he's been sitting in jail in Nevada for a long, long time. And that's when he decided, I guess he was bored, didn't know what to do with his time. That's when he decided he was gonna write his book, If I Did. Johnny Cochran had died by that time. I don't know that if any of his other lawyers were still involved with him, but he goes to write it. Well, when the Goldman family, the civil case, they won their case. They got a $30 million judgment against O.J. So the criminal jury said, we don't believe he killed these people. He walks free. The civil jury said, we do believe he killed these people, and he owes their families $30 million. So O.J. was never gonna pay that, okay? That was the point where he like left California, moved to Florida in case he had to declare bankruptcy. God knows he probably dropped the Heisman in the Bermuda Triangle or something. Nobody's ever figured out where the hell the Heisman Trophy is, or any of his other little goodies. He managed to stash a lot of money and do all this stuff.
That's why he was in Nevada.
Yeah.
In the hotel, trying to get his
Yeah,
time
yeah,
back.
yeah. Well, that may have been one of them. That was never clear to me. But anyway, so he goes to jail later for the robbery thing and, decides he's gonna write this book. Well, the Goldman family had been trying to collect on that $30 million judgment for a very long time. Because, as I said, he sold everything in California, moved to Florida. He did that because Florida had more advantageous bankruptcy laws. So that was his plan. If they come after me and try to actually get the money, like seize my assets and stuff, I'm moving to Florida because in Florida I can put $15 million into a home that I live in. I can pay cash for that and live in my house, and I can declare bankruptcy and none of my creditors can get me kicked out of my house. All my money is sunk in my house, right? That's where I invested all my money, and in Florida, they can't take your money. In California, they can. They can't take your house. In California, they can take your house. But Florida and Texas, you can screw over your creditors by putting all your money in a house, and as long as you're living in the house, your creditors can't touch you in a bank. They can't touch the house in a bankruptcy proceeding. So he did that. So he goes to trial, and then he decides, well, but here's the problem, right? He's telling them he doesn't have the money to pay the judgment. So he also can't, when he was free, he couldn't run around spending all this money either, right? Because he's saying he doesn't have it. So if he starts, buying like 3 Bentleys in 6 months, people are gonna be, where did the money come from for that? Where'd that come from? So you do have money, obviously, right? So he goes to write the book, and eventually Ron Goldman let him know that you go ahead and write. The family was gonna fight it. They were like through with him. They didn't want to relive this. They didn't want to hear his version again. But then Ron Goldman's lawyer said, dude, think about it. If he makes $1 gazillion off the book, you get 30 million of that. That's where your money lies. And then let him write his book. Let him make a bunch of money. We're gonna take it all because he owes you $30 million. So at that point, when that became obvious, O.J. went, yeah, I'm gonna shelf that idea. So the book really never got published. Or if it was published, it was yanked off the stands pretty quickly. It never really got sold because all the money was gonna go to pay off that big fat judgment. So he screwed him over again. But anyway, that's O.J., yeah.
Whenever someone gets sued and they don't have the money to pay them back, what happens? Like, these families
We're
still...
talking about that in about 10 minutes. Just hang on, I'll tell you exactly what happened.
Last question, isn't there a way, can a court send an order, asking to see your financial?
Yeah, I'm getting to that. We're gonna talk about all that in a minute. Let me just wrap up
You
with
don't have
this.
the money, you don't have to prove you don't have a gazillion
We're gonna talk about that in just a minute. Let me do a couple of other little hurdles we need to get over before we get to that. So, you go to trial. If you're the plaintiff and you win, great for you. The defendant may say, yeah, but it ain't over with yet, right? We lost, but we're going to what? Appeal, correct. So, we've already been over that, you appeal to the next highest court, if you lose there, you got one last shot to the Supreme Court. And, you know, if you lose there, well, it's pretty much all over with. So, we've already talked about what happens at the appeal court level, I'm not gonna go through that again, but remember it, the appellate court judges have only the record from the lower court to look at, they don't talk to witnesses, they read everything off the transcript. Most cases, on appeal, the judgment of the lower court is affirmed, meaning the appeals court says the judge didn't get it wrong, the jury didn't get it wrong, we're gonna let their decision stand. Remember that either party, however, can appeal. So let's say the plaintiff won, but she doesn't think the jury gave her enough money. She thinks that she proved that she had more losses than the jury actually compensated her for. So the defendant, who lost the case totally, appeals, asking the appellate court to reverse the lower court's decision and say that the defendant should have won. And the plaintiff appeals and says, well, the defendant definitely should not have won, the jury got it right, I should have won, but the jury did screw up one little thing. I proved $100,000 in damages and they only gave me 50. So I'm asking the appeals court to increase that to 100,000. The appeals court can grant remedies on both sides in that context. So let's take a 10-minute break. When we come back, we're going to talk about how do you collect your money. If you win the lawsuit, how do you get the money?